Thank you.
Tuesday, March 12th at 4 p.m. to order. First off, we want to welcome Christo Blagel as a new member of our panel here. Thank you. Welcome aboard. Thank you. Can I take a roll call, please? Sure.
Okay, so we've got Kelly,
Terry Kelly here.
Wisner,
I'm here.
Blakeoff,
Here.
okay, Hecht here, and Sadler,
Here.
and Doran.
Here. All right, need a motion to approve the agenda.
So moved.
Second.
Okay, we have a approval and a second. All in favor? Opposed? There is, the next item is to approve the April 2023 Zoning Board of Appeals meeting minutes, as well as the Allen Gorky decision document. Do we have a motion?
I move approval.
A second? I'll second it. All in favor?
Aye.
Opposed? At this point in time, I would like to open the public meeting at 4:03 p.m. 3:03.
No, that's.
Oh, that's,
Four.
you're right, 4:03. Sorry. Got me.
Daylight savings time.
And before we get started, I have a little notice to read. This appeal is an administrative appeal. It is a legal process to resolve disputes regarding ordinance interpretations and decisions made by the zoning administrator or plan commission. The burden of proof is on the applicant to prove the zoning administrator or plan commission made an error. The zoning board of appeals is to review the record and decide if an error was made. They may allow new evidence if decided by the zoning board. The zoning board has all the powers of the decision maker and may reverse, affirm, or modify the decision that has been appealed. Tonight, our attorney, Randy Nesbitt, will be present to provide advice to the board and to swear in those that provide testimony. We will then hear from the appellant and his attorney. Following the appellant's testimony, we will hear from anyone in support of the appeal. Those in support of the appeal will be given one opportunity to speak and shall limit their testimony to 3 minutes. Next, we will hear from the zoning administrator and any attorney representing the administrator or commission. Following that, we will hear from anyone in opposition to the appeal. They will have one opportunity to speak and their testimony is limited to 3 minutes. The appellant will be given one opportunity for rebuttal, and then we'll allow a rebuttal from the zoning administrator. Period. Please remember, this isn't to decide if a project is good for the area, if there's enough room, or other issues. Rather, it is solely to decide if an error was made and the testimony needs to be pertinent to that allegation. Thank you. Next, okay, we have some mail. This is from Amy Lorona, 5700 Tapadera Trace Lane, Austin, Texas. March 7th, 2024, the Village of Sister Bay Zoning Board of Appeals. Subject: support for the appeal regarding removal of a sign for the Dorr Hotel. Dear members of the Zoning Board of Appeals, I am writing in support of the appeal being brought by Chris Schmeltz of the Dorr Hotel Holdings LLC. concerning the removal of a small sign located on village property adjacent to the Dorr Hotel. As the former general manager of the Dorr Hotel located at 2329 Mill Road, Sister Bay, I wish to express my perspective on this matter. In July of 2020, I was engaged as a consultant on the Dorr Hotel project. One of the primary matters under discussion at that time presented to the Planning Commission was the hotel signage package. Initial renderings were shared and subsequent adjustments were made based on feedback received from the Planning Commission. Chris Schmeltz, the developer, then presented these revised plans to the village administrator at that time, Bo Burnoff, along with other village officials, including Denise Berto and Dave Leno. Specifically, I vividly recall a sidewalk I vividly recall a site walk through conducted with Mr. Barnhoff on February 2021, just before the signage installation commenced. During this inspection, Mr. Barnhoff expressed positive remarks regarding the aesthetics of the signage, noting how it complemented the character of Sister Bay and would enhance the area visually. Additionally, during this walkthrough, discussions regarding other aspects of the project, such as parking, lighting, and landscaping, were held. Were held following the installation of the signs on March 2021. Another property tour was arranged with Mr. Bernhoff and Denise Berto. During this inspection, there were no indications or discussions, suggestions, any non-compliance issues with the village signage regulations. Drawing from my prior experience as the marina manager for the village of Sister Bay, where I had to navigate compliance codes and processes concerning signage, I firmly believe that Mr. Schmeltz followed the appropriate procedures. He not only obtained approval from the village administrator, but also received affirmation from the village board and planning commission. In conclusion, I urge the zoning board of appeals to consider the evidence presented and grant the appeal brought forward by Mr. Schmeltz. It is my firm belief that the sign in question was installed in accordance with the village regulations and with the appropriate approvals. Thank you for your time and consideration in this matter. Second is a two-from subject matter. It is from James Lowmiller. Good afternoon, Janelle. My name is James Lowmiller, General Manager at the Dorr Hotel here in Sister Bay. I am writing on behalf of Christopher Schmeltz and the Dorr. I was present for a tour of the property in late April, early May of 2021 with Mr. Schmeltz, Ms. Denise Berto, and Mr. Bo Bernhoff. We toured the hotel prior to our opening to the public. We did walk the parking lot upon Ms. Berto and Mr. Bernhoff exiting the property. Through those specific conversations, I cannot attest to. I feel the signage was discussed and no further action was to be taken. I am available anytime for follow-up if necessary. Kind regards, James Lowmiller. Okay. So who's going to speak today?
Good afternoon, Mr. Chair. So, ladies and gentlemen, thank you. I represent the appellant, I guess would be in this circumstance. My name is attorney Will McKinley. I'm with the Min Law Firm in Appleton. My intention to proceed today, if it's okay with you, Mr. Chair, is I'll just start by giving a very brief opening remarks. Then Mr. Schmeltz will offer testimony if he needs to be sworn in or otherwise. I'll ask him some questions and he can provide his position on things. We also do have two additional witnesses that I was intending on having offer testimony today. One was actually the woman whose letter you just read. I wasn't sure if letters were going to be read as part of the record today or not. But she intends to appear remotely. Her name is Amy Larona. And then the second witness who will be here in person today is the former village administrator, Zeke Jackson. So then I would offer that testimony along with exhibits, and then we'll conclude with some remarks. So if that's acceptable to the chair, that's how I'd like to proceed, unless you had some other preference.
It sounds good to me.
Okay,
Go ahead.
I'll try not to keep us here too late. Don't be too intimidated by the heat. Ladies and gentlemen, thank you for taking the time to be here this afternoon and for your willingness to serve on this very important tribunal. As I indicated, I represent the petitioner, Dorr Hotel Holdings LLC, and Mr. Chris Schmeltz. Today, we are asking you to review an order issued by the village administrator dated December 21st, 2023. In a nutshell, the village administrator and the village plan commission contend that the Dorr Hotel sign on Mill Road is illegal, both in the location of its placement on village property and the fact that there exists a drop-down component to the sign that was not contemplated as part of the original permit. As we will outline for you this afternoon, we maintain that the sign at issue was not only consented to by the former village administrator and plan commission chair, but has been standing open and obvious for years without any issue. We believe that the village's beef isn't with the sign, but is instead with the fact that the Dorr Hotel contractually has the right to claim exclusivity over parking spaces within the shared lot that abuts the hotel. My client is not the bad guy here, and the evidence will show that the Dorr Hotel has done everything above board with respect to the signage at issue. We are confident that once you hear the evidence to be presented, you will be satisfied that the village administrator's order is inappropriate, that cooler heads should prevail, and that the order should be overruled. And with that, I would like to start with Mr. Chris Schmeltz. And we were unsure if, again, he was going to have to be sworn in or if he could just offer testimony. So I'm going to proceed in what would be a more formal fashion with the direct examination of him.
He's gonna be sworn in.
Mr. Schmeltz, can you raise your right hand, please? Do you swear to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you.
Can you state your name, your full name for the record, please?
Christopher T. Schmeltz.
And Chris, can you explain your relationship with the village of Sister Bay in terms of the various projects and property ownership you've had over the years here?
Yes, as it relates to Sister Bay Marketplace, which, so Zeke Jackson will be joining us in person. He's going to be on via Zoom. So Zeke Jackson was the administrator at the time. I engaged Zeke when the property at the previously known as the Braun property was for sale, and the village was seeking a hotel project and development on that site. At the time, it was a parking lot for village use, and it was my understanding that they were looking for a larger project, and the hotel was always part of what was to come there. That followed, before that, to give a little context, in 2008, when the village purchased the Helms Hotel, which was right on the waterfront, which was part of a grander, amazing feat by the board at that point to open up the waterfront on Sister Bay. So they tore down the 45 room hotel, the Helms Hotel. And I think it was always the villages or the board at that point thought that another hotel would come in and take its place. So Zeke and I had a relationship with Zeke and presented, we were looking to do a restaurant on the corner. And we subsequently made a proposal in 2016 for the purchase of that property. We broke ground in November of 2016, completed the project in May of 2017, so with the opening of the Chop restaurant. at that point, Zeke and I had a conversation and they were, I think that the village had gone out to Chicago, other markets looking for someone to do a hotel. From my understanding, I wasn't a part of that, but the offers that were on the table were, hey, we want to build a hotel here, and people would say, well, okay, give us the land and we'll see where that goes. We decided to take a different approach and said we would accept what they were offering. That was $500,000 for the land, to really take control of the remaining property to put on the Dorr Hotel in 2 phases. There was going to be the construction of the hotel itself, and then retail in front, which we have not been able to complete because there's always been this parking question that's come up repeatedly. So I'm kind of going, yeah.
We'll get into more of the details, but tell us some of the other projects you've done here within the village.
It purchased the Lure restaurant. It was currently, before that was the Mission Grill. Out of that, we did 2 other projects with Zeke. We did the Marina View condominiums with a partner, and then also the Shoreview condos with a partner as well.
And you believe you've been a good partner with the village over the years?
Yes.
Always tried to be collaborative and work collaboratively with village administration and find common ground on how to move forward with things.
Yes.
Now, you're here today to challenge the village administrator's December 21st letter that was sent to you, correct?
Correct.
Okay, and this is, again, I don't know if we mark exhibits or not, but this is gonna be marked as exhibit 1. I'm just gonna, can I just take one pass it down? Be a lot easier. Some extra ones if yes. Thank you. Give you that one because it's marked. I do have a couple more. That one's not marked. Okay. Okay. Chris, I'm gonna put in front of you the document where I am giving you what a document that's been marked as exhibit 1. Is that the order we're talking about today?
Yes.
All right, I want to walk through this letter, this order a little bit. So this is a decision that was issued, and it says, it starts off by stating that there was never an easement granted by the village board authorizing your use of village property, and no lease arrangement or money exchange to let you utilize or lease village-owned property to erect the sign that is at issue today. Did I read that correctly?
Yes.
Okay, so that's one issue, is the placement of the sign physically on village property. That's your understanding?
Yes.
And then the letter goes on to state that after a sign permit was issued, a small second sign appeared below the permitted sign. Did I read that correctly?
You read that correctly.
And-
Yes. Yeah.
And we'll get into that. And there wasn't permission given by a committee to erect the second sign on village-owned land, correct?
Correct.
Okay. The letter then goes on to provide some of the procedural background that leads us here today. And then if we go to the second page, which in this document is marked page 3, we see the order at issue, and that says that the Village of Sister Bay Municipal Code, you are hereby ordered to remove your sign from village-owned property for failure to obtain a sign permit prior to erecting the sign. Did I read that correctly? And then it goes on to state that the sign has to be removed by January 21st, 2024. Then if we go to the last page of this letter, which would be the last page of exhibit 1, it says that if you fail to remove the sign, you'll be fined $452.50 per day. Did I read that correct?
Yes.
And also that the village, this letter says that the village employees may come and physically remove the sign, correct? You obviously take issue with
Correct.
that order.
Yes.
Now, I want to start our conversation with the signs at issue and give the Board of Appeals some factual context. So let's really start from the very beginning about the signs themselves. So I want you just to explain to the Board of Appeals, how exactly did the sign first come up, and just give us some chronological history. But before you do that, I'm gonna introduce 2 documents here, 2 additional exhibits that I think will be useful to start with. So the first exhibit is exhibit 2, which is the offending sign, and then exhibit 3, which is another sign. So Chris, why don't you go ahead and provide some backstory on the Signage issue in terms of your interactions with the village?
Well, as Amy said, the process of going through plan commission, through the parks commission, it was, it started in July of 2020. So the project, we broke ground on the hotel in 2019. We didn't have branding at that point. We went through a branding package and COVID hit us. So everything becomes compressed and hard to meet with anybody, not for that matter at this point, but we went through a branding package, presented the signs, we went back to parks, we went to the plan commission, so probably it's over 3 or 4 months of working back and forth, collaborative information. You want me to go into the light bulb?
Well, let's stop for a second and just for the benefit of the members of the Board of Appeals. So Exhibit 2, can you just confirm what Exhibit 2 is?
Exhibit 2 is the current sign on Hill Road.
And then that's the sign that is being objected to by the village.
Correct.
And then Exhibit 3, what is that exhibit?
This is the sign.
Okay. And our understanding is that really the issue here is the drop down on Exhibit 2, that additional drop down signage, correct?
Correct.
The one that says reserved parking for the Dorr Hotel patrons.
Correct.
And then to your knowledge, the sign that's on the highway, Exhibit 3, that is not being objected to.
Correct.
So the issue here is not that sign, it's just the sign that's on Exhibit 2 and the fact that it is got a drop down component to it, correct? So I want to next then introduce a document that will be marked as Exhibit 4. Chris, can you identify for the board what Exhibit 4 is?
So, and I apologize, there's a lot of information, but if we don't go through and get the right information, that's where we end up with these issues. So I know this is a lot, here are the sides. But if you don't go through how it happened, I think it just becomes, somebody said, somebody else said. So Exhibit 4 is, we submitted the signed permit applications dated December 17th, 2020. On the bottom of that, it does say plan share approved via phone call on January 6, 2021. Subject to conditions imposed by Parks, Properties and Streets Committee, with respect to moving of the street light. That was discussed in, I think it was in January of 2021. And this is the original application. Actually, it was a second version of the application, and what we're saying is what's not in the record is the third version of the application that shows the drop down sign.
And we'll get to that in a second, but let's just, for the benefit of the board, talk a little bit about Exhibit 4 to make sure we have our bearings straight. So to be clear, on January 19th, 2020, correct?
Correct.
This isn't a question of whether or not there was a permit issued, it's a question of what does the permit allow? Is that your understanding?
Yes.
Okay. And if we go to the document, so Exhibit 4, and it would be page number 4, even though it's technically the third page of this packet. We see as part of this documentation, it appears that there were 3 signs that you were applying for a permit. And the one that is labeled PP2 is the one that is on Mill Road, correct?
Correct.
And where it's depicted on that page is where it's located now, correct?
Correct.
Okay. And then if we go further into 4, I want to start at what is on this packet, page number 7. And that is for sign PP1, and what is that sign?
So that's the sign on Bayshore Drive.
So that's the one on the highway, that again shows a drop down, correct?
Correct.
And then if we go to the last page of Exhibit 4, this is for sign PP2, which we addressed previously. And what is this?
So this is a sign, a version of the sign that shows the language actually on the sign on the logo.
Okay, so here it says reserved parking for hotel patrons, correct? That's it's a little difficult to read, but that's what was there. So explain then, Chris, you had said that this paperwork was submitted, but then there were subsequent discussions with whom?
along this, during COVID, so along this time, we're going through, we're not only talking to our branding group, we're talking to our investors, we're talking to, as he said, Amy's a part of this. So a lot of people we're talking to collaborate information to make sure we're getting a great product and a great logo and sign. So part of this, we go through and look at this, our branding group, and they say, you know what, you really, around your logo, you shouldn't have language on your logo. It should be dropped below that. So that's when well,
So then I'm gonna then go ahead and show you a document that's been marked as exhibit 5. There might be one that comes around. Chris, can you tell us what, on exhibit 5, what are we looking at here?
discussion regarding potential removal and relocation of the street sign at the entrance to the parking lot for the Dorr Hotel on Mill Road. Consider a motion for action appropriate. This is January 11, 2021. Meetings of the Parks, Properties and Street Committee.
Okay, so why are we talking about a street sign or a street light being removed, I should say?
Yes, the street light is going to be right in front of where the sign is.
So who is asking you to move it?
I was asking the village if it was okay. That's where I signed.
And the sign was on the village property at the time. That's where it was contemplated and that's where the street was.
Correct.
So there was never in your mind, ever any question or doubt that the village knew that this sign was being placed on the village's property.
Correct.
Your sign, that is. Okay, now I want to then, as part of exhibits, this was exhibit 5, excuse me. As part of exhibit 5, I want you to go to the second page of this document. Or excuse me, the third page of this document.
Yes.
What are we looking at here, Chris?
Are you on third page?
Third page, I'm sorry. So the third page of exhibit 5, what are we looking at there?
This is the reserved parking for the Dorr Hotel patrons.
And this is a rendering, correct?
Correct.
And then the next page is what? Also a rendering, correct?
Correct.
And these were produced by you presumably,
By Jones sign, yes,
but on your behalf.
correct.
And were these shared with the village administrator at the time as part of your discussions for the signage and whatnot?
On the last version, so we did on the third version of our sign. They were.
And we see in this version, we see the drop down, correct?
Yes,
And we see it says reserved parking for the Dorr Hotel patrons, correct?
correct.
And so is it your testimony that this document, this version was ultimately given to the village administrator as part of the discussions about the final signage that would be placed on Mill Road for the Dorr Hotel?
Yes,
Okay. Was there any objection or any sort of resistance to this signage?
no,
And then we heard, I believe, Miss Lamanna's letter that was read into the record earlier. And she had talked about there being some site visits, site reviews. Tell me about what happened there.
yeah, so part of the plan commission and streets and parks committee meetings. There was, what was resolved was that if we were gonna move the light pole, it had to be Denise and Bo needed to be present and confirm visually on site where it was gonna go to, and it would be operable. So that was one. The second was that, and it was in minutes, that the landscaping around the sign needed to be appropriate, and it was gonna be signed off by Denise Berto and Bo Berto.
And never any objections or concerns raised about the drop down sign or I guess what I would call the change from the original submission for the sign permit to the final.
No objection.
And again, your testimony is that you submitted these revised plans as part of the ongoing discussions over the signage to the village administrator.
Yes,
Did you actually meet with the village administrator to discuss the changes?
yes.
And what was the context of those discussions?
Just to go through and make sure, and obviously dotting our i's, crossing our t's, presenting it to him, that this third version, this is what we're gonna do. I even have on my sign, I don't know if Will has that in his, piece he's gonna share with you, but when we signed the last Jones sign, approval, signing off on it, it's dated December 18th, so a day after we had the initial, that's in the record, or I guess in the village's file, and it does say on there, we need to make sure this is approved, that the signage is approved, so that was the last step we needed.
And Chris, just from a chronology standpoint, the final, again, if we're talking about exhibits here for the record, on exhibit 5, where we're seeing the drop-down signage, these documents were provided to Mr. Bernhoff prior to the issuance of the permit, correct? Or do you recall?
I don't recall.
Okay.
Did sit down, Janelle and I had talked about it, she remembers me coming in and discussing it, and Janelle doesn't know the context of me, put you on the spot there, but did remember me coming in and discussing, the sign, coming in to talk about it.
Okay. How long has the sign been sitting in its current form?
It will be 3 years, the 30th of this month.
Up until this current controversy, has there ever been any objections or issues raised by anyone at the village regarding the drop-down sign on the road?
No.
Or the placement of the sign on village property?
No.
Okay. We did ask Bo to appear today, correct?
Yes,
He declined.
correct. Citing legal reasons for, previous administration.
Okay. And again, we have independent verification from Ms. Lamana, or excuse me, Larona. I keep calling her Lamana, I apologize. And she can offer sworn testimony today via Zoom, if we need to get to that point. So, and I just want to also verify, substantively speaking, the language, the words that are on the signage, they don't say anything different than what was originally in the documentation that accompanies the permit, correct? It wasn't like you changed any of the substance of what was trying to be conveyed.
No.
And the sign itself, size-wise, everything else, you didn't expand the footprint, or you didn't go bigger or change colors, do anything that would otherwise be a meaningful deviation from what was at least included with the permit documentation.
Correct, we did not go over the sign, about the sign square footage.
Okay. Just so the board knows how much, I mean, you had to remove a sign pole, obviously install the sign. What was your out-of-pocket cost approximately for this sign?
It was thousands of dollars. I had the receipt. I could dig it up. I haven't been able to find it.
Okay, and as part of this order, what is your understanding of what you're actually being asked to do with this, with respect to the language of the order?
Julie and I did sit down with Nate Bell, village president, to discuss it. I think Julie's wanted us to at least remove the bottom portion.
Okay, and your position is you don't have to, correct?
Not only that I don't have to, I feel like it's leading into something else, and we're going down a road. Let's just sweep this under the rug, and so I want to be firm on this because it leads to we have parking there, and I feel like the next step is they're going to now ask for us to take away parking.
Okay, so let's talk about that, because it's your position that you feel that there's kind of an underlying undercurrent here that's really driving this. This isn't about the sign per se and whether or not it complies with the original permit or not, but you believe it's about the parking situation, correct? Okay, so you have a development agreement with the village of Sister Bay, correct? And you talked a little bit about this as you were kind of starting off. And I do want to actually offer a copy of the development agreement for the record.
This is a lot of stuff, I'm sorry.
You don't worry, I'm not gonna go through it.
Yeah,
Part of this
but
is,
again, the context is like you have to go through each step, otherwise it just gets lost, so sorry for the.
so,
detail,
part
yeah.
of the document marked as exhibit 7.
Yes,
What is this document?
This is our development agreement.
Okay, and on this development agreement, can you just give us, this was a contract between you and the village of Sister Bay, correct? And this dates back to 2019, correct?
Correct.
And the purpose of this development agreement was effectively to discuss the rights and responsibilities of you as the property developer, but the village as the village in terms of what you were going to do with what was known as the Sister Bay Market.
Correct.
And as part of your negotiations with the village over this, I think you might have testified previously, but there was the parking lot was already sitting there on this land at the time you entered into this agreement.
Correct.
And it was your desire to actually buy that parking, correct?
Correct. We'll need parking to do that.
Right, you can't have a hotel without a parking lot for patrons, that tends to be an inconvenience. And you had wanted to buy the parking lot, but why didn't you? What was the reason you couldn't?
The village, a lot of discussions about parking, and so we were told that it was purchased, with state funds or public funds, and it couldn't be sold directly to someone, it would have to be exchanged. And so we were told that be patient, and this is in documents throughout the years we've talked about this. The village president at the time, David Lino, said, Chris, trust us. You just have to trust us. You know, and I said, okay, we'll keep going. This is obviously a major investment for not only myself, for our partners and investors as well. So we're putting trust in it, and that's why this is so important to go through all this documentation, all this language, all this work that we put into it, to make sure we get to the end that we have a parking that we can park.
So on exhibit 7 of your development agreement with the village, at page 4, you're gonna go to page 4.
Yes.
You'll see there's a highlighted section. At paragraph E of this, on this page, it says the parking plan, which was reviewed and approved at the August 21, 2018 meeting of the Plan Commission. The Plan Commission approved the addition of 30 parking spaces on the previously mentioned property, and also stated that 20 of the spaces in the Sister Bay Marketplace parking lot shall be allocated for use by the developer for a total of 50 spaces. So what ultimately was the deal that was struck between you and the village with respect to this parking lot that they couldn't sell to you?
Was that we were gonna be allowed to, mark spots and reserve them for hotel patrons.
Okay. And that was critical to your willingness to go forward with this development.
Yes, the first meeting we had with the village to introduce the project, the concept of it was to talk about and get parking improved, that we knew that was gonna be an issue.
And
Potentially.
if we go to page 6 of exhibit 7, we see that as part of your responsibilities under this agreement, you have the duty you're responsible for all the snow removal and everything from that parking, correct?
Correct.
And there are still spots available for public parking within that.
Correct.
And your sign, the signs we talked about tonight, does not say that public parking is prohibited. It just says that there are spots that are reserved for Dorr Hotel patrons, correct?
Correct.
And that is the truth.
Correct.
And that is the deal that was struck with the village of Sister Bay. I would like then you to go to one last page in this tome. So if you go to page 26, and then the next page. That's unnumbered.
Okay.
And we see here that this was an ordinance that was enacted years ago. And this were an ordinance, I should say for the record, it was enacted in 2016. And it says specifically that lots 1, 10, and 11 are intended to facilitate public use and enjoyment and the development of lots 2 through 9 and 12 of the marketplace development. Did I read that or summarize that correctly?
Yes.
So again, it was envisioned that the Sister Bay parking lot that was there was intended to help facilitate exactly what it is you're trying to do, which was to put in a very nice hotel downtown Sister Bay. True? Okay. Now, again, more for the record than anything. I didn't kill enough trees today, I had to make it another one. I want to show you a document that's been marked as exhibit 8. All for a little sign.
You're not charged on by the.
I wish, good thinking. Not put it on camera.
Well, is there an exhibit 6? Am I missing one?
I don't think we've introduced it.
Okay. Then-
We have not.
Okay.
Thank you. Okay, Chris, what is exhibit 8?
So this is the amendment to the development,
Okay,
dated November 6, 2019.
and so we have the original development agreement, and then if we go to page 2 of exhibit 8. We see yet again references to the parking plan. And in fact, we have now increased the number of spots that you're entitled to within that lot from 50 to 52, correct?
Correct.
And this was approved not just by the village president in executing this document, but was also approved by the plan commission, correct?
Correct.
And approved as to form by the one and only Mr. Nesbitt, Attorney Nesbitt, sitting here today. Chris, now I'm gonna show you a document that's been marked as exhibit 9.
All this paper will be recycled, so that's the bright side.
So Chris, looking at exhibit 9, can you tell us what we're looking at?
This is the parking lot of Cincinnati Marketplace.
Okay, and what I've done in my chicken scratches here, I've taken the liberty to annotate the various parcels that are at issue with respect to the parking lot. And as you can see, that half of the parking lot, or I say 3/4 of the parking lot would technically be owned by the village, is that correct? Correct, approximately. But 1/4 of the parking lot is actually owned by you. It's on your,
Dorr Hotel Holdings.
correct. And the driveway, at least would be the west entrance, is half on your parcel and half on the village's parcel.
Correct.
Correct, okay. And the sign at issue is again placed between the 2 entrances on the village's parcel, correct? So in this circumstance, again, you own some of the parking stalls outright, but then you have a contract with the village that says you have the right to exclusivity on parking spots that are also on the villages, correct? Now, you're willing to work with the village to obtain title to this parking lot, correct?
Yeah.
Your preference would be just to own the parking lot and be done.
Correct.
That those offers or those gestures have, how they've been responded to.
So Zeke, and I think Zeke might get a phone, has been, that was kind of our talking through it, was that the way to do this would be through a transfer. It couldn't be sold directly to us by some state statute or what, how it was publicly funded. Bo and I would work closely to discuss it. Nothing ever came. Bo left, and I brought it up to Julie about doing that, and we talked about options, but nothing in this
Nothing's
came
been
up. Yes.
And instead, you're just being fined $450 a day to take down your,
13,000 a month. Yes.
right. Okay, so Chris, at the end of the day, what are you asking this board to do for you?
To dismiss this. And work with us to finalize this development so that we could have ownership of the parking lot and work with the village. In whatever capacity, so we could have parking and provide parking elsewhere.
So in other words, work together just to try to make this issue a non-issue.
Correct.
All right, nothing further with you. Thanks, Chris. I don't know. Who we have. Zeke, are you on?
I am on, Will, and I will tell you that I have 16 minutes prior to a fire commission meeting that I have to attend.
I promise you it will take less than that.
Okay.
Trying to clip right along here. Randy, does he need to be sworn in or no?
Yes, Zeke, could you raise your right hand, please? Do you swear to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Zeke, could you state your full name for the record, please?
Matthew Zeke Jackson. Hi, Tom. Hi, Randy. Hi, Janelle. Hi, Chris.
Hi there.
Hello, Zeke.
I should say,
Can you turn on your camera?
I'm trying to. It says it's on my end. I can hear you. I can see you. I don't know why you can't see me.
Okay, well, you tried.
It's
All right.
it's saying it's on my end.
Okay,
Well, I think your voice is distinctive enough that everyone can verify it's you.
Okay.
You certainly don't need any introduction here. Zeke, you're here voluntarily, correct?
Correct.
You're out and you're aware, and you've obviously been on, and so you've heard kind of the factual background here with Chris, correct?
Up until December 12th, 2017, I was administrator and have had conversations with Chris after the fact.
Sure. So really, the reason why I wanted you here today, Zeke, is because again, Chris's testimony is that he feels that really the sign issue is kind of an underlying symptom of a much bigger problem. And that problem has to do with kind of the shared use of this village-owned parking lot and the fact that it wasn't sold to Chris back in 2018, 17, when we were doing this development. Are you familiar with that?
I am aware that we're here at a zoning board of appeals meeting and discussing the matter. Yes, sir.
Okay. So I can't show it to you because I thought you were going to be here, but I am gonna mark something and I'm gonna, for the record. And then I'll just read it to you because it's gonna be very brief. Give me a second, Zeke, I'm just.
Yeah.
Handing out stuff if you can't see. There'll be no things down. Sorry. So Zeke, I've introduced the document that's been marked as Exhibit 10. And just for your reference, this is a letter to you back in 2016. So we're going back a long time ago. And this was our kind of initial correspondence relating to the Sister Bay Marketplace and his initial purchase of some of the lots. And essentially, there's an exhibit, attachment A, that's a contingency to this. And for the board's record, or for the record in general, if you go to the page 9, and then the next page would be the document I'm referencing. And Zeke, in this document as attachment A, the contingencies were that the village would provide adequate parking on sites 1, 10, and 11, as listed in the Sister Bay Marketplace, and that parking provided for planned unit development and the needs of the village during peak season would be addressed. So the reason why I introduced this is, Zeke, can you confirm that parking from the get-go was a concern that had to be navigated by Chris and the village with respect to what was being envisioned for this development?
Will, I will do you one better than that, and that is to read from you can't see on camera, but I have it sitting here in front of me as part of the original board packet from December 12th, 2017, and the board report that I wrote. That would be a public document. I'll quote from that. It says, please listen to Mr. Schmeltz and help him to understand the expectations of the village as it relates to parking. We will all have to work together to constructively arrive at a development that works for everyone. He's eager to involve the village in the planning process at each stage to ensure the project is a welcome addition to the community. I will also read from that same report. It says, I've asked Mr. Schmeltz to do a draft site plan to justify his understanding of our parking code. Parking will drive the total number of rooms that can be achieved, as well as the facade work and building height. Also in that same report, second paragraph in, there will be considerable more work to be done on the site to bring it to a point of being ready for final approval. Most of the uncertainty lies in how parking will be handled by the village and interpretations of the code.
So, Zeke, again, I know you weren't around for the development agreement, so I'm not going to ask you anything about that, but at least during your tenure, was there general ambition by the village to do something productive with this land, with this site?
Yes, sir.
Okay. And is it fair for me to say, at least by the time of your departure, that, there was a working relationship, a collaborative relationship between Chris as the developer and the village in terms of trying to just get things done and get things done so everything looked well?
Yes.
And Zeke, again, because you're not here, so I can't show it to you. but I'm going to just mark it, even though it's really not an exhibit, but I do want it, I think it's important for the record. And as the former village administrator of the village, are you familiar at all with the sign code?
I am familiar up to 2017, and I would tell you it's been a very long time.
You mean you don't have it memorized?
You know, I did once upon a time, Will.
So the only question I have for you, and if you can't answer this, that's perfectly fine, but I want to draw the board's attention to section 66.0750. This would be page 117 of exhibit 6. And I'm just going to read this aloud, and if it says the zoning administrator may waive the requirements for certain plans, specification, data, or drawings when the application is to execute minor alterations or repairs to a sign, provided that proposed construction, alteration, or repair is sufficiently described in the application for the permit. So Zeke, again, I know you had nothing to do with the approval of the sign, but in your experience, having worked for the village, did it happen from time to time where changes to permits would be made informally without there necessarily being documentation in the file?
I do recall that being a substantiative part of permitting. That would be my statement there.
And based on your understanding of kind of what happened here with respect to what the original concept was to the conversion to a small drop down with effectively the same language on this sign, is it possible, based on your experience, that it just simply wasn't noted in the file, that the documentation wasn't there, but that it was approved, especially after hearing Mr. Schmeltz's testimony?
Will, I don't want to speculate. That's a question you'd have to ask them both.
Of course, he's not here, so we can't.
Sure.
All right, Zeke, I don't have anything further. Thank you so much for your time today.
Yes, sir. Take care, guys.
Thanks, Zeke.
Bye.
Yep, see you guys.
And then she. Our other witness, again, the letter was read into the record, so, and she's not here, but her letter will stand as stated. So I just 1 second to confer with Chris, and then I think we're done with our presentation.
Here's a summary. If you want to kind of stuff, yeah,
That's
yeah. Yeah, so no, again, a lot of data, Will and I spent a lot of time through this. Will's been helping us on this project throughout since 2016, and so I thought it was important to read all the documentation to show that we went through this process was not just a hey, this looks good, go ahead. It was, we went through plan commission, we went through parts, everybody wanted to see it, saw the signs. Part of this was so what Julie is saying to me is what's in our file is it doesn't represent what's there, and I disagree with that. What's in what she showed me in the file was our second version. We did the next day. I signed a document with our Jones Sign Company to approve this last version, and I wrote on that signed portion of it. I said this needs to be approved. So that's when I went into Bo and personally talked about it, and Bo approved it. And so I with that, it was approved. So then Bo and Denise came, looked at the sign you're seeing here. On this picture, you can't see it. The light pole is right here. So this was taken March 30, 2021. So Denise and Bo had to come in. This is during COVID. So Denise wanted to wait until the end of the project. And so I had to talk, say this is where the poles today. We're gonna take it out and move it over here. We had to reroute so that our power would be then powering our sign. So we had to do a lot of electrical work there. Then also they had to come back and improve our lighting. Sorry, not our lighting, but our the landscaping that's around the sign too. So twice they went back and looked at it. There was no issues with the sign. And then so here we are, almost 3 years later that there's an issue. Well, in the packet, when I was asked by Julie to come in front of the plan committee, it says Dorr Hotel sign and the Knowles Nelson stewardship grant. So really, it's the sign is not the problem. It was, this is my opinion. it was because they're bringing me there about this Knowles Nelson. Knowles Nelson is a part of the grant program that I think was bought, that those funds, and Steve can verify that it was the boutique in front of Al Johnson's. That was then DOT when they did the widening the road to bury the power lines. They then used those funds to buy the Braun property to have a place for redevelopment. So a lot of moving parts. So that's my feeling of why this is being issued today. And what I'm really worried about, why this is so important, this seems very minimal, because the next step is, well, now we're taking your parking. So I just want to make sure that we're presenting all the information, all the data, so that we, at the end of this, hopefully you saw the progress and how much effort went into this, how much has gone in to share all this information, dig up all this data to clear the air of how this process went. And it's unfortunate Bo couldn't be here to share his side with our discussion. That would just clear it up, would be done. So that's, I just want to make sure, share with you, and I would like to talk about that next step of, we would like to purchase that lot, work with the village to transition that parking, because when we bought this, as Will pointed out, when the Sister Bay Marketplace was put together, it was meant to be parking for businesses that would go into the Sister Bay Marketplace, and so now the Sister Bay Marketplace is now complete. Although there's two developments, there's at least one last phase in the front of the hotel and behind shop. But we don't own the parking, so it's kind of a stalled situation that we would love to get resolved. And that's, I'm happy to work with the village, as I have been all along to get this resolved. So thank you for your time, appreciate it.
Okay, thank you for a very enlightening presentation. Does any members of the board have any questions before we proceed?
Sorry for all the people.
Yeah, I'd like it, the parking lot. How many total spaces are there?
There's 74,
Okay, and you have 55.
2, I think, yeah.
Well, I thought the thing said 55. 52?
Let me just interject. Our group here today is not discussing the parking lot in any
No,
shape.
But I just was curious, because that's gonna lead me to where I would go. But, and it also says permit required, if I'm not mistaken, on yours,
Yes,
on the ground.
correct, yep,
Okay.
yes.
Let me be clear to you that we are gathered here today to discuss the sign and the sign only, its legality or its illegality. And you've enlightened us on all the other issues, but that will be for another day with another group. Are there any other people here that would like to testify on behalf of the issue at large today? Yes, sir.
I would. My name is Patrick Quinn.
Okay, Mr. Quinn, we're gonna swear you in.
Mr. Quinn, could you raise your right hand, please? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
I am the owner of the property across the street, or at least one of the units in that development at 2330 Mill Road. The owner of unit number 1, but at the time I was the co-builder of the project when Chris was going through his approvals, as we both were in plan commission. And all I'd like to say is that we received a lot of help from plan commission, although a lot of make sure your T's are crossed and your I's are dotted. And more so than any other plan commission that I've dealt with back home and from Green Bay. But the point is, I was impressed with how thorough it was, although sometimes challenging. But let me just say, as a guy that was across the street at about the same time, with the same issues from Zeke to Bo to Denise, that there were always a lot of moving parts. And anything that we did, I felt, at least from my perspective, was closely analyzed by both Denise and the Plan Commission and its members and the staff. And I proceeded with approvals from them. And felt confident and comfortable that I was doing the right thing. And that was just my experience with plan commission and what I was told and what was approved. And so I don't want to get into all of the detail that you have in front of you, but that was my feeling that what was okayed at that point was and is okay now. So, do you have any questions for me?
Okay, thank you.
Okay, you're welcome.
Okay, the next part of our agenda here is our village administrator.
My name is Julie Schmeltz. I'm the village administrator, and I was the author of this letter. I was directed by the planning commission to enforce their orders, you should say, or their verbal communication to Mr. Schmeltz. After he failed to remove the sign, they asked me to proceed with whatever action it took to make sure that sign was removed. So I issued the letter.
Let me stop you a second.
Sure.
Do you swear to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you.
I'll be honest with you, I'm not sure where to begin. When somebody appeals a letter or they give the reasons for those letter or the reasons for the appeal, and that is what we all proceed on. So I prepared my defense to you based on the appeal letter. That's not exactly what was talked about here today. They gave a list of some other things and they went on about a parking lot. This has nothing to do with the parking. This comes down to, you got a permit for a sign and that's not what's there. Take it down. And we're not saying take down the big one. It was very clear you have to take down that small one because that small one never had a permit. But I'll start with the appeal reasons that were in the letter. So the letter talked about the first allegation, and I'm sure you have their appeal in front of you, the document they submitted when they filed their appeal. The first allegation was that I erred because chapter 66 states an order can only be issued from the zoning administrator, not the village administrator. And they further say that the order applies if I'm issuing an order from section 66.054. It's very confusing. First of all, I do have a copy of my employment contract here. I really don't want to make copies, but I can certainly give it to Randy or Tom. They can verify this is what it says. But I was hired as the village administrator, hereinafter referred to as the administrator / zoning administrator. So in regard to that first allegation, I am the zoning administrator. It also says that he's referencing section 66.054. He's saying the order referenced that, but the order, you have the letter in front of you, the order does not reference section 66.0754. It references section 66.0791. I believe you have a copy of the order and again, their appeal in front of you. And section 66.0791 is the compliance section of the code. And it says, except as otherwise authorized, no sign visible from a state or county road, from any village street, private street, public parking lot, private parking lot, from the water or from adjacent property shall be located, erected, moved, repainted with different colors, reconstructed, extended, enlarged, or structurally altered, including the placement of various components of the village, until a permit has been reviewed and approved by the planning commission or designated representative, and a permit has been issued to the property owner or building occupant by the zoning administrator. My order says, here's the compliance part. I cite that section of the code that says, you can't have a permit unless it's been approved by a permit. They're talking about section 66.0754. I don't know why, but that was their first allegation. Again, that I'm not the zoning administrator and that they're referencing something that wasn't in the order. Allegation 2 was the order is unclear as to whether the sign must be fully removed or just the drop down sign, rendering the order ambiguous. I think you've heard them testify tonight. They know that it's the small sign. But I will make prepared response. As for the letter with the order, I don't know how much more clear I can be than to write on page 1, bottom paragraph, because the second sign referenced earlier in the letter that exists cannot be legally authorized. Or on page 2, first full paragraph, when I remind him, the smaller sign was to be removed by October 26, 2023. Or in the second paragraph on page 2, when I remind him the smaller sign was to be removed, and if it wasn't removed by the meeting date mentioned, staff was directed to remove the sign. Or in the order itself where it says Sister Bay has not given approval to place a second sign on village-owned land. Or in the notice when I ordered the small sign hanging below your primary sign located along Mill Road will be removed. Or in the final paragraph where I urge him to remove the sign in question. And also Schmeltz was told in meetings from the Plan Commission that they were referring to that small sign. So in regard to allegation that it's unambiguous, they didn't know which sign I was talking about, I think it's pretty clear that the letter, in my mind, the letter was very clear. It was referring to the small sign. Allegation number 3, the sign at issue was in fact approved by the village. I have prepared quite lengthy document and I don't want to burden you with more paperwork, and I have it to share with you and I'll hand it out. But basically what happened is, Mr. Schmeltz had applied for a sign permit on August 28th. And he knew that if you revise your drawings, you have to apply again. There's a big sticky note, Chris will be submitting revised drawings. It was not approved, and then he was actually told by the administrator, Bo, at that time that, look, I can't approve this because at that time he was referring to the language because that first sign talked about parking for CHOP. And Bo was like, look, we've given you parking credits for CHOP, but you don't get any designated parking for CHOP, so I can't approve this sign. So Chris comes back with a different sign. And you've seen that in the packet. It's basically the one that shows up as 3.0. It's just a sign. It's just a sign. It's got some writing below it referencing the parking lot. Nobody's arguing that. Nobody's questioning that. But there was no second little sign hanging down from it like there is now. And it's that second little sign that's hanging down that we have told him we want removed. Yes, he knows those second little signs take permits because that's what he has on Bay Shore Drive. And that's what he included on his application for the Bay Shore Drive sign. He has the application for that sign showed the little one. The application for the Mill Road one didn't show the little one. And that's the one that we've ordered removed. And I'll hand that out quickly. Allegation number 4. The village issued a license to maintain the sign as evidenced by the fact it's been there nearly 3 years and by virtue of the development agreement. First of all, we don't issue licenses, we issue permits. We also don't issue them to maintain the sign, but to erect or modify a sign. He's referencing maintain. Our code talks about maintaining a sign when you're talking about dilapidated or deteriorated signs, which this one is not. The code says if something doesn't continue in conformity, the village can initiate remedial action. That's section 66-1550 and 1560. And that is what happened here. So we have a sign permit for a sign and it did not continue in conformity. So now we can take remedial action. We're trying to be nice and saying, take down the small sign. And oh, by the way, we own that property and you don't have a contract or a lease with us to have your sign on that property. We want to play nice, take down your small sign because we can technically use our remedial action and just go take the whole thing down. We're trying to be nice. Take your small sign down. It may have been 3 years, but we also lacked staff during that time to enforce some of our codes. I have a hard time believing that we apply for one permit, that's all in the file. We apply for another permit, that's all in a file. But then there's a third one that there's no notes in the file and that Denise Berto would have approved. I'm not sure if any of you are familiar with Denise Berto. She knows the code very well, I'm sorry. Denise is actually the one who said, that sign's gotta come down. I can't imagine Denise would order it down if she previously approved it. That's not Denise's style. All signs do have to be approved by the plan commission chair, and Denise had approved the original one that was issued. She never did approve, or the file shows she never approved, and her testimony at hearing shows, or at meetings shows, she never approved that small little drop-down sign that was there. They reference the development agreement, and they say that the sign was authorized by virtue of the development agreement. You have it in front of you, so I'm not gonna hand it out, but if you go to section E, it's called signage, street signs, and traffic control signs. The developer hereby agrees that, number one, business-related signage is not part of this approval and must be applied for separately. Further, any representation of the business signage on the approved plans is representative only and is not approved as part of this agreement. So it wasn't approved by the development agreement. Notes on some of this stuff. But I did talk to Bobo, did call me. He's not here, not for legal reasons, but ethical reasons. As a public administrator, you take an oath with the International City County Managers Association that you abide by certain ethics. And one of them is I don't want to use the word sabotage, but you don't go to a different community where you work to cause trouble. So that is why Bo had explained to me why he would not be here. Great to hear Zeke's voice. I've heard a lot about Zeke, but Zeke was not here during the sign permit, during the sign discussions, during the application, during the review. That was all Bo. Zeke had nothing to do with the sign. The letter from Mr. Lohmeyer, he does not say, he doesn't really say anything about the sign. He just says, let me pull it up here. He says, I feel the signage was discussed and no further action was to be taken. That doesn't really tell me anything. What sign he's feeling, doesn't say he remembers, doesn't say what it was, so, I think it should be dismissed. As far as Amy, she talks about, how this went to, in July of 2020, one of her primary matters under discussion at the time presented to the Plan Commission was the hotel signage package. Initial renderings were shared, yada, yada. That's not true. I've got all the minutes from this sign in this packet right here. And the sign went to the Plan Commission on April 28th of 2020. He asked, and that's just because Chris went there to ask how much signage would be allowed. The Plan Commission explains that you get 81.4. They go through some of the sizes, but there's no sign review. There was no sign review. The next time the Plan Commission meets was June 15th, 2020. The Plan Commission work session meeting. Chris Schmeltz is present. The discussion was about parking. But Chris asked about the existing public parking sign and if we'd remove it, or somebody would remove it, because he's developing. He doesn't want that old sign there. The request was referred to the Parks, Property and Streets Committee. In June of 2020, the Parks, Property and Streets Committee discusses the sign. And the Dorr representative asked that the public parking sign be removed from the lot. Again, the one that government type of public parking sign that goes on there. Minutes from minutes state Bernhoff did contact the former village administrator as well as representatives from the DOT regarding the issue. And was informed that the village did utilize grant funds which were obtained from the DNR as well as funds which were received from the DOT to purchase the property. DOT informed Bernhoff that they do not mind how many spaces are allocated or used by patrons, nor do they want to get involved in determining how further allocations will be made. But he was informed that in order to satisfy the requirements of the previous mentioned grant, a portion of the Sister Bay Marketplace parking lot must remain available for use by members of the public. He had not had an opportunity Bernhoff hadn't had an opportunity to contact representatives of the DNR regarding the issue yet, but based upon his findings to date that he is recommending that at this time, the public parking sign be left up until such time as the construction of the hotel is nearing completion and the previously mentioned hotel guest parking only signage is erected. So you can see they weren't, the plan commission wasn't discussing Chris's signs. They were discussing the public parking sign and DOT and the parking lot itself. Next thing in the file, and in all the parking and, or I'm sorry, plan commission and parks committee minutes was August 28th when Chris applies for the first sign, which I believe you have a copy of. Like I said, I prepared my response based on the appeal form, which is what they stated they were appealing. And that is what was published in the paper and made available to the public. Tonight, we've heard that, I mean, they didn't even address those things that were on the appeal form, so they're not following their appeal, I guess. They came up with different things that are not part of the appeal, and they went way off target on this parking lot issue. That's not the issue. They appealed my letter. My letter said, remove the small little sign. You don't have a permit for it. The file shows you don't have a permit for it. The code says you need a permit. And the code says if you're in violation, we got to take remedial action. So it was, the remedial action in this case was take down the small sign. And I will say, that was being very kind, because at the plan commission meeting, the order was, you take your park staff out there and you cut that sign down. And I'm like, whoa, I don't want to be doing that. So I offered him and said, you got 30 days, take down the small sign, Chris. That's all I have.
I have a question. Could he, write, I just lost it, write for a permit for the little sign? Or is that not a possibility?
I don't think he can, and I'll tell you why, because I'm a stickler with the code. And the code talks about, parking signs, parking directional signs, and they can't exceed 24 inches by 30 inches. And they've already exceeded that. So to have that, they would, first of all, you don't get off-premise signs. This is an off-premise sign. I don't know how it was allowed. I think that kind of got lost when they were trying to help Chris get signage out there. Then your parking signs can't exceed 24 by 30, which it does. So we wouldn't be able to do that.
But the parking sign is just the little one, the hotel sign is the big one, would be my understanding.
But the sign that we had approved had the name and then it talked about parking.
So I have a question too then. It was presented exhibit 5 that there was a rendering that actually shows that current sign. So obviously that was presented to the village at some point.
Yeah, I'll show you what was,
They must have seen that. So, and it has that little part there, so.
well, the render, so the only little signs that we were shown was, so there's two signs. One on Bay Shore Drive would have the little sign and the one on Mill would not. So it's tricky, but you gotta look at the corresponding page. And I'll give you the information, but I'll hand it out just so it's part of the record. As a courtesy, I will give you guys one.
Thank you.
I don't know what your exhibits were, but that's one of the two things that I have, so you don't really need exhibit numbers on them. So if you flip through it, like I said, you'll find that first sign permit application, which was, he submitted on 12/17/2020, or sorry, that's that second. Yeah, the first one has a yellow sticky note on it. That application was put in on August 28th, 2020. And if you flip through there, you'll see different signs. The one that was supposed to be on Mill Road is the one that's labeled 6, in the upper right, it'll say sheet number 6.0. Or, I'm sorry, if you have the diagram on the side, it's gonna be lower right. It's gonna say sheet number 6.0. So that's what was originally submitted for Mill Road.
So that's that's the printing on the big sign.
Right, now this one wasn't authorized, though. So this was his first draft.
This one was not,
Nope, that was his first draft. So if you
Okay.
keep flipping through it, then
Okay.
now you're gonna come to one dated 12/17/2020. And if you go to the second page, you'll see the approval. So you know this is the one that was approved. We're gonna keep flipping through here.
What is the sheet number on that one?
So this one, sheet number 2.0 is what's on Bay Shore Drive. So that was the one that was approved for Bay Shore Drive.
Yeah.
And then you go to 3.0 is what was approved for Mill Road.
The 3.0 on the bottom.
Yep. And you know that's the one for Mill Road, because if you look at the top of the page, it says externally lit post mounted panel sign quantity 1 Mill Road. So we know that's what was applied for and authorized for Mill Road. And yes, he did show this schematic. He showed the Bay Shore Drive sign and the Mill Road, what the Mill Road sign would look like. You can see that Mill Road one does not have a little sign hanging down.
You know, on this, it has the printing at the bottom.
Yes, at the bottom of the sign. We don't have an issue with the printing on the bottom of his sign. That's why, you know, this argument that they don't want me to advertise that parking lot. We allowed you to have printing on the bottom of the sign. What we don't want is a second sign hanging down. And what we ordered was the second sign that's hanging down because it doesn't have, not because of what it said, but because it doesn't have a permit. Leslie, the only other thing I want to add is the language about waivers, how we can give waivers. If you go to the code, it says you can, zoning administrator can give a waiver, provided that the proposed construction, alteration, or repair is sufficiently described in the application for the permit. So it's not like you can just give a waiver. So it's a little misleading to say, oh, staff has the ability to give a waiver. You got to read the whole section. It says, provided it's well documented. So if there was this change that they say we made, or they made that we approved and nobody has any documentation of that or memory of that, the code says you have to have it documented before you'd approve it. So I really do not think Bo or Denise would have allowed that change and not documented it somewhere. That's all I have, unless you have questions.
Is there anybody else in the audience that would like to speak against the proposal? Are there any more questions for any of the panel members?
Am I correct that the sign was taken down by the village? The drop down sign was taken off
No, it's
by
still,
somebody?
it's still sitting there. It's hanging down there. Chris
Okay,
said
it's
that
out today,
he
yeah.
can't, yeah, Chris said it's too difficult. It'd be costly to, he'd end up ruining his whole sign if he took that down, is what he told the planning commission.
Okay, I thought it was down for a while, yeah, okay.
So that sign has never been taken down,
Not since we've told him it's gotta come down.
and the plan commission has directed that it be taken down in 2 different meetings.
The plan commission instructed that it be removed. It was August 22nd. They say put it on the agenda for the next meeting, so on September 26th. They say the sign is misleading because it implies the marketplace parking lot is for hotel guests only. Berto explains the sign that is on site is not what was approved. Schmeltz argues the sign was approved. The commission votes and orders the small sign which infers parking is for hotel guests only to be removed within 30 days. Schmeltz said he wants more time to research the sign and discuss it at the next meeting. Bell explains, well, 30 days falls a few days after the next meeting, so you'll have time to research it and still meet the order. October 24th, the plan commission there's October 24th plan commission meeting. On October 19th, Schmeltz sends an email saying he won't be present, but attaches a copy of the sign permit application for the sign in question. The applicant shows the sign with no little second sign below it. The sign reads door and in small print below, reserved parking for hotel patrons. Schmeltz sent a memo and a copy of the permit application authorizing the sign. His attorney also submitted a letter regarding the sign issue is symptom of a much bigger problem. The attorney writes, the only difference between the rendering and the actual sign in place is that the text was dropped down into its own placard in the insertion of the word the door in front of the word hotel. So he admits that it's not what was there, what was approved. They discussed Schmeltz's sign and reaffirmed their decision that the small sign under the large sign must be removed. November 20th, plan commission meets again. Schmeltz is not on the agenda and therefore not present, but under public comment section, Berto notes that the small sign has not been removed and requests Schmeltz give an update at the next meeting. Then the last meeting they talk about it was December 12th, 2023. Plan commission meeting, Chris Schmeltz is present. Berto notes that since the sign is still in violation, a citation should be issued and Schmeltz take whatever enforcement actions are necessary.
Okay. So that was 4 different meetings.
This past fall.
So I have a question.
Sure.
So why did you build the sign the way you did, knowing that this was what they agreed to and not with the drop down?
Well, so we talked about 3 versions. So there was the first version that had chop on that sign that Julie
Okay.
mentioned. But that was denied. And the second version, was the one that had the language right on the sign.
This one, it has the language right on the sign.
Yeah, so that one. So that was part of the permit, and then I remember I referenced that the date that we signed that permit was December 17th. The next day, I get new plans from Jones Sign that takes it off of the sign itself and drops it down to match the sign in front, on Bay Shore Drive. So they're both those signs that are the same. Why did we drop it down?
No, I'm asking why you didn't do what they gave you the permit for.
Well, he did give me the permit. So then.
So I'm saying, they did give you the permit for this. Why didn't you do it this way, knowing that this is what your permit was for? And if you weren't gonna do it this way, why didn't you go back for a different permit?
So that's what he testified to previously, is by the time the permit was issued, there had already been a subsequent approval of the drop-down sign by Bo. The debate here is really.
But we don't have anything that says Bo approved it.
Correct, except for the fact that the zoning code 66.0750 sub L does state that the zoning administrator can approve minor changes to a permit application.
I understand all that, but when a zoning administrator does that, do you not record it?
You record everything.
And
So that's my point.
I understand.
We don't have anything to reference saying that Bo says, and he wrote his name and said, I say it's okay.
Well, I would dispute that because you have testimony of 2 individuals with firsthand knowledge today. Mr. Schmeltz, who was directly involved in the conversations and then his former employee. You also have the former village administrator, Zeke, who testified that it did occur where modifications to permit applications for signs would happen without being documented. So I don't think it's unreasonable to take Mr. Schmeltz's word.
I have a hard time with it only because we work with the documents. We don't work with hearsay, basically. Which is, I'm sorry, but we have to go with what we have. And it's my understanding if Chris had done it this way, there wouldn't be any problems.
Right.
And if he had said to Jones Sign, oh, you're gonna change it, wait, I have to go and get another permit. That we wouldn't be here today. Because I'm assuming they would have tried to go, yeah, we'll do that because that's what your sign on 42 says, or looks like. I guess that's my point. We don't have anything to work with other than hearsay.
That's not the case, because this is, Chris has testified specifically as to what happened in terms of the interactions, not just what Bo said or didn't say, but the fact that these meetings took place. The renderings that we're seeing, were in front of the committee. And essentially what's being said here is that taking a village employee, administrator, zoning administrator at their word is not allowed if the documentation isn't in file. So you're putting, again, Mr. Burnoff can testify. There's nothing prohibiting a witness from testifying in an evidentiary hearing. He wasn't called here today. The village could have the village has subpoenaed. They could have subpoenaed him to appear and testify. They knew what our argument was. The absence of the witness shouldn't be held against us. It should be held against the proponent of what they're saying he didn't say. We're saying that he said it. Chris Schmeltz is testifying in front of you today under oath that this is what was said. Another person submitted a testimony here. There is no testimony. There's no evidence from the other side that refutes that, other than the absence of it. Which that in and of itself can't be necessarily held against Chris, because your own sign code acknowledges that that could happen. That there could be approvals without there necessarily being a subsequent documentation or some sort of subsequent ratification in writing by the village.
But if Jones Sign had made the changes, did you take the picture to him and say, this is what they're changing it to, or?
Yes.
Absolutely.
That is
And
his
so at
testimony
that
today.
point, why wouldn't you have had him sign off on it? I don't understand the gentleman behind you said, yes, he worked with the village and had no problems, that they went through, dotted their i's and crossed their t's and all that kind of stuff. I'm having a hard time understanding why you wouldn't, in that meeting that you're saying you had, which I don't doubt you had, why you wouldn't have a signed permit or whatever you want to call it, that Bo said, yeah, we can work with this, let's go with it. That's my issue right now.
Can I answer that?
No, we're gonna stop right there, because we gotta continue the meeting process, then we can continue this. So actually, the next part of the meeting was for you to offer a rebuttal to what you heard today.
And I think this was a good part of that rebuttal process.
Well, I would think so too. That's why I'm counting it as so.
So again, I mean, I've actually articulated a large part of our rebuttal. So first of all, when we file an appeal, we will state every possible legal ground for appeal. That's what lawyers do. That's how you preserve a record. Today, we focused on the key issues that we think are relevant, the non-legal issues that are relevant, the fact-finding part. That's what your job really is here for today. As I stated, there are no witnesses. There's nobody here for the village that has firsthand knowledge of any of this. The village administrator who testified today wasn't here when all of this went down. We have testimony, actual facts, factual sworn statements from individuals who were involved with the process. The individual, like you said, Bo, would have been here, was not, could have been subpoenaed by the village, was not, chose not to be here. That's fine, that's his prerogative, I don't have an issue with that. But I do have an issue with holding his absence against Mr. Schmeltz, when Mr. Schmeltz is the one who is here to actually testify. I also take issue with the fact that, again, the code allows, it envisions, maybe not the best practice, but best practices by the village should be held against Chris as the developer. Chris, in good faith, was working with the village on this project for years, went in, provided new renderings to the zoning administrator, the village administrator, who holds that dual role, as Ms. Schmeltzer has pointed out, I concede. Pointed this out, spoke with Bo. Bo said no problem. Well, why did he say that? Because honestly, if you look at the two signs, it matches the one that was approved by the village in terms of the drop down. This wasn't some new fancy novel thing. It was exactly like the one on Bayshore. It's just now going to be on Mill Road. Two, the substance of the text was immaterial. It wasn't significantly changed where we're adding, new terms or conditions. It's just the same thing. It's just literally the style was adjusted. So it's logical that Bo said, yeah, that's no problem. It's the same thing. Who's going to object when they've already not objected to the one on the highway? And so they proceeded. Should Chris have gone back and said, I want this in writing, I want a CYA letter, so that way I know? He's doing that now, but at the time, the working relationship with the village was such that, and again, the amount of scrutiny that was going on with this project, as was testified by this gentleman. The fact that this thing could sit out there, literally driven past constantly to and from plan commission meetings, and tours being taken, and never once objected. Why did nobody object? Because it was approved. It was approved by the village administrator, and there's no evidence here contradicting what Chris has testified. That's the reality of today. So that would be my principal rebuttal. Again, in addition to pointing out that the sign code does give the zoning administrator discretion. And it's not that there's got to be well documented. That's not anywhere in the language within that code. Otherwise, I mean, I guess I can provide some closing remarks if this is the time to do it, or if that's for.
Leave your last chance.
This is my last, oh, so you guys are just waiting for me to shut up. I can see exactly how it is. I have prepared remarks, and I just want to read them into the record.
Okay.
So I do appreciate your patience. You serve a very important function, and part of your function on this body is to try to kind of see the forest from the trees. Sometimes these disputes, people get entrenched, and I think it's important for this body to kind of look at the big picture here. We did present a lot of factual history, because that factual history is relevant to this dispute, because this wasn't just a fly-by-night, put up a sign and try to get away with it. This was a project that literally has been in the works since 2016, and it has been a very strong collaboration between the village and Mr. Schmeltz. This wasn't just putting up a yard sale sign. There was a lot of discussion, a lot of meetings, and a lot of oversight that went into this. So it is reasonable when Chris comes in and testifies under oath that those renderings were provided subsequently and that they were approved by Bo. That's not unreasonable to take his word, especially when there's nobody here to refute that. This is a lot over a little sign. Is a lot over a little sign, to be sure. And the village has chosen to make a big deal about it, so we've had to make a big deal about it, because it's not as simple as just taking the sign down. It will require a new sign, and as the village administrator has said, we can't just go back and do it over again, because they basically said they're gonna deny it. We can't do it because apparently it's a directional sign or whatever. So we gotta fight for the sign, and it's right to fight for your rights as a property owner. The documents and testimony, Chris, in the letter that was offered into evidence, and again, Zeke's background confirming that it does happen that after that zoning change, sign permit changes do happen undocumented. That there was a deviation from the original plans that was submitted. That Bo was aware of that deviation, Chris testified. Again, the lack of proper paperwork is not detrimental to Chris's argument here, because the zoning code recognizes that deviations can occur as long as they're minor, and these were minor deviations. This wasn't a substantial change in signage. Again, the sign was there. It's been sitting there for 3 years. And again, for whatever reason, now it's a war on signs. I don't understand it, but it is what it is. Your task is really to ask the question, why pick this way? And they may say it has nothing to do with the parking. We believe it does. We believe that's what motivated this, because if that sign disappears, then all of a sudden Chris's ability to regulate that parking lot, which he contractually bargained for with the village under the development agreement, is significantly interfered with. The reality is, he was given dominion over the parking lot, 52 spots. He met and worked closely with the village for years over every detail, down to the landscape on this project. He received approval from the village administrator for the sign as it sits today. That sign has sat for years without controversy, and it's only now that it's becoming an issue. The fact that there's nobody else that's appeared here tonight objecting to the sign, complaining about the sign, pointing out how it's problematic. But we've had lots of people coming in and confirming what Chris is saying to you should be meaningful. So in light of the totality of the circumstances, we ask that you overrule the December 21 order and find that the sign at issue is properly permitted and it's allowed to remain as is without further ado. In the alternative, if you find that there hasn't been sufficient evidence to confirm that, we would ask that you stay any action against the sign for 30 days, that you suspend any accrual of penalties that are being imposed, so that Chris can either come up with a plan for remediation or file a certiorari action with the Dorr County Circuit Court to take this further. We hope it doesn't come to that point. We don't want it to come. We've tried to collaborate, we've tried to work, we're not trying to be unreasonable here. Because we did everything we were supposed to do as good developers and good partners with the village, and now we're being punished for it. That's simply not fair. You can remedy that by overruling the order tonight. Thank you.
Okay, now we hear a rebuttal from the village
Could
administrator.
I add one last thing?
Go ahead.
Because, sorry, so.
No, wait, hold
Go
on.
ahead.
Yeah, so I just, the certified mail letter that Julie had sent on the sign violation. The third paragraph says, after the permit was issued, a small sign appeared below the permitted sign. So it gives the illusion or the perception that we put up the sign and then later on added this sign all along. It was always put up as one sign. And that, I just want to clarify that. And secondly, mistakes happen. You mentioned, I gave Will the printout we went over, we talked about, and he approved it. The fact that he didn't put that in the file, I would, thank you, Bo, sorry, Bo, the village administrator at the time. When Janelle and I, we all make mistakes, things happen. So this is the variance, the Village of Sister Bay appeals variance that we filed. It says received January 18th, 2023. It actually should read January 28th or January 18th, 2024. Civil mistake, it happens. When Janelle or Julie, I'm not sure who sent it out, for this meeting, they asked for rebuttals. So anybody who wanted to send an email in, they listed Janelle's email. It was missing a period. So if anybody wrote to that email and found what was on that piece, it was wrong. So my point there is mistakes happen. There are little things that happen. We all get by them. And this was an oversight by the fact that Bo didn't put this in the file. We're here today. Thank you.
Okay, Janelle?
Okay, so, just response. We would not subpoena Bo because we had no idea that's where this conversation would have went, because we were relying on the reasons for appeal stated on the form that they submitted. Even if Bo was here, he would not have approved it because, or even if he was given this, he would not have approved it, because it was an off-site or freestanding sign. It was not an on-premise sign, so he would not have been able to approve it if it had been given to him. If somebody had went to him and said, hey, we want to add this little white sign there, he wouldn't have approved it because the sign would have exceeded the allowable square footage. They bring up the fact that the sign was there 3 years and nobody made a big deal out of it. I'll be honest with you, we didn't have staff to enforce codes for a period of time in that. I think you're all aware of that. When Bo left, there was about a year maybe before we hired somebody else. They say that deviation is allowed. Again, I read to you that section of the code. Deviation is allowed if it's well documented. It does in 2 places. I can share that with you. I'm pretty familiar with the code. And then they said that the fact that nobody here is objecting to the sign means, that you should grant it. That's not what this is about. It's not about can you keep a sign or not. It's about, did a person make an error? That's me. Did I make an error? And then you have to prove that I didn't. That doesn't mean it's popularity contest or we like it or we don't like it. It's all about an error. Was an error made or wasn't there? I disagree with giving them 30 days to comply with it, to give them time to start another appeal in court. I don't think that's the way it should work. We're coming upon the spring season. The Plan Commission has ordered this down months ago, and we just keep lingering on. As a matter of fact, the only one of the reasons why this letter was written is their attorney stated in a meeting that they didn't have anything formally in writing. So we're like, better write the formal letter to them. Not only that, we wanted to anyway. We knew it was because they wanted to appeal it, and it's the same thing, extend it, give them time, because they want to do that formal appeal and keep it going all over a little sign on village property without a contract that the village can go out there and remove at any time. The extra time doesn't do them any good. We can take that sign down whenever we want. Lastly, I just want to submit to the record that the comment that Bo he would have made a note and file, right? This is a note from Bo. This is in your packet. It follows April 20th minutes. And as you can see, Chris was asking for something, and what does Bo do? He documents it. He puts approved. So this particular issue, which isn't the same issue, he does. This goes to show what happens when you change a file, when you change a sign, staff documents it. The fact that it's not in the file shows it was never documented. This shows that we do document, that Bo does document. So if Bo had been presented with a change and had Bo approved it, Bo would have documented it. He documented things. That's all I have.
Yeah. At this point, we're gonna close the testimony part of this public hearing. And then the next section is called deliberation amongst the board members. Okay, anybody? Let's get the Bo issue out first. Does anybody believe that, based upon what you heard today, that Bo gave tacit approval for this, although there's nothing in writing? This was given to us under oath, and the meeting did occur, and that is alleged that he did give approval.
I believe that.
You believe it? Okay.
I don't, it's not that I don't believe Chris, I think I think he believes Bo said yes to it. I don't have a doubt that he doesn't believe it, but I believe Bo would have documented it.
Okay.
Absent of something in writing, I'm gonna have to say it didn't happen.
Okay.
I'm thinking there probably were comments to that effect, but, you know, again, there's nothing, unfortunately, there's nothing concrete. And this has grown into such a big brouhaha. For those of us who have ever raised teenagers, this is reminding me of the fact that, you know, the allowance that was a nickel short now becomes the national debt in some way, shape, or form. Can't an application be put in? Can't that be given, or some kind of leeway be given? And the village and the hotel people could get on with life? I mean, this just is 17 reams of paper to each one of us about something like that. This is just utterly ridiculous tonight. That's my 2 cents.
Okay.
And it's free.
I agree with the nays for the Bo issue. I guess it's telling to me that he was offered a chance to write something or to be on the back screen. And it could have really helped clarify, because it's so fuzzy and woozy out there, but he chose not to, so I have to go with my own feelings that there may be a meeting, but there's nothing concrete that shows it to me that it did happen or was approved. The issue of people going out and doing an inspection, which included Denise and Bo again out there. I think on those tours, you're looking at what's been done, how nice it all looks. I don't believe you're looking at something and looking to say, well, this is wrong, unless it was blatantly wrong. And that they looked at the sign And they didn't, neither of them made an issue that this placard on the bottom was there and should not have been there. So. Those are the two things that were brought up, which were mentioned that would sort of certify that it was passing approval again, because they looked at it and didn't say yay or nay about it. You've been given your, this is what we have to fill out.
Can I comment on that, Mr. Chairman?
Oh, you can, I would welcome your comments.
Thank you, thank you.
Give us directions.
And I appreciate the fact that Janelle provided the decision document, but this really relates to a variance. And I don't want this to divert itself into a variance. And all of the assumptions and the requirements that apply in terms of hardship, exceptional circumstances, all these other issues all deal with variance.
Right.
For the sake of this board, what really needs to be done is a motion to either approve the appeal, grant the appeal, which makes then a determination that the zoning administrator's order is incorrect as a matter of law. And then after that, agree to some reasons that support the decision. And, you know, normally that would be using this decision document. In this case, I'm going to ask you to avoid the decision document because I don't want to apply all of those conditions that would apply to a variance, as this is very much different.
Can I ask her one more question? Or is that, are we done?
No.
No, don't go back to questioning anybody
Yeah,
Okay.
at this point. Now
that's
you're,
why I turned those.
now you're
Yeah, you have
in
to
a
accept that
deliberation.
your own, yeah.
Yeah.
You can ask amongst, you know, for clarification amongst us. You can ask your question.
I just was about the permitting going back to permit the sign. But if I remember correctly, she said it couldn't be permitted because it would go over the size.
Size.
It was, right, it was.
So the only way it could be done would be to redo it with it, either make it smaller with the little hanger or put it back on the sign.
That's what I understand.
Right.
Thank you.
That's what, yeah,
I guess
I agree.
that was what I was trying to.
That's what I got.
Is it possible for this board to grant the appeal and to allow that variance that the sign be that much larger? What is it? It's a matter of inches. We're not talking huge. And let everybody go on with their life.
A variance might be possible if it's applied for. There's not been a variance applied for in this case. This is done under the strict interpretation of an appeal. And there is the potential for a variance to be applied for under the sign code.
Can that be a condition to grant the appeal and that condition? With that condition?
That's an interesting question.
So.
I'd rather the court
They
not
have
tell
to
us the
file for
answer.
variance then, is what you.
Well, I'm just thinking that with the, you know, then you have 30 days to apply for the variance or whatever. But, you know, it just seems that,
Well, let me put it this way. If you grant the appeal, I'm just trying to process this through my mind here. If you grant the appeal and say, all right, the order is eliminated, the order is illegal, then there's no need for them to apply for a variance.
Right, it's gotta be one of them.
Yeah, I think it has to be one or the other.
Any other thoughts? Our role, as stated in the statute, is Board of Appeal is to, and the administrator spoken very well, our whole purpose here is to determine that did the administrator or the plan commission, in some cases, err in the judgment that they made, whether it's been issuing a directive or analyzing the case. And in my opinion, all that we have heard today, what in her world that she has done, I don't see any errors.
I agree with you.
Yeah.
I mean, we're working with what she's working with.
In the process.
I
of
also
that-
understand trying to get a variance and make it work, because I'm all about making it work. It's not obnoxious or anything like that, and if it's, you know,
Well,
half an inch or 3 inches.
My question would have been just. Now, I can't believe nowadays that the sign company can't come back to the original door. Big sign and somehow add that wording, Dorr Hotel Park, whatever was approved.
Onto the sign that's already there.
Well, that was my thought, that, that could always be done, I thought that.
Yeah.
They could go back to the
And I-
original and just, and add the language on the bottom of the original sign.
And I can't believe that it's that hard to take down the.
It's- I think it's built in. It's not hanging or anything. I think it's metal up in there.
So you
You'd have to hacksaw it or.
cut it through and.
Yeah.
Well, I think you'd have to remove the sign and to begin with, if you were going to add language on the bottom, or make the new sign.
No.
Or-
Attorney,
I was actually going to ask for a 2-minute recess to confer with the village attorney, if that is appropriate. As
It's
to,
up to the chair.
or I can just throw out, I was gonna move or make a motion, I don't know if that's a thing. And now I'm doing my trial practice stuff here,
Right.
so
what's going on? The hearing was closed.
Then, yeah, it is closed, and you just started speaking.
Yeah, what I think you're probably aiming at is to amend this to a variance.
no,
Oh, all right.
I can't speak, so I will not.
No, we'll continue with where we're going. And where we are right now, and we're gonna bring this together, so. That's, that's an option for them to decide, I don't know if they wanna do that, then they don't have any issue. Then they
Well,
can
I-
also take this to the next level, that's why it's recorded, it goes to circuit court, and then they have a judge rule. And the judge can rule then, that we were wrong, administrator was wrong, so.
I was gonna say, if the fine per day is $452, something like that, and it's $13,000 a month, I would think putting up. It would be a lot cheaper to put up, take the old sign down and put up a new one, it's not gonna cost. That much money, I would think,
Right,
so to me, that would make it.
well, it's got to that stage where a notice of a fine has been issued, so that's something that has to be.
Correct, figured out if they're still gonna charge him per day, correct? I would say no. I would say if he corrects the sign within so many days.
But that's not a.
But that's not us.
Really, it's
That's
not,
us.
no.
No, we can't,
Okay.
no, you can
Just the
bill
sign.
it.
Okay.
But what I'm saying is, if it's out there that it's gonna be $452 a day.
Right, what you're saying has value.
You got that hanging over your head, just fix it, and then you have to pay $452.
All right, right. Or get an overruling at a higher court.
Well, or that.
So. Make a motion that, the village administrator did not err in the issuance of her papers and documents on this particular matter.
Oh, you want me to read it?
Yes, I might read
Okay.
how it's translated, my translator.
Okay, that the zoning board of appeals finds that the village administrator / zoning administrator and the plan commission did not err by ordering that the small sign on the Sister Bay Marketplace property for the Dorr Hotel be removed.
Okay. Is there a second?
I'll second it.
All in favor?
Aye.
Aye.
Well, we'll come down the line. Yeah,
Aye.
Aye.
aye,
I'm not voting.
okay.
Aye.
Abstain. Okay, the motion is carried.
Now you should look for reasons. Make a motion as to approving reasons to put in the decision document, reasons for that motion.
Okay.
I know there was discussion about no documentation in village records.
By the previous,
Previous administrator, it is stated that the previous administrator, gave approval for his particular sign. However, there is no documentation to support it.
yeah, I gave verbal.
Make a verbal approval, Jim. The plan commission has met 5 times, excuse me, 4 times, and directed that the sign be removed. And as of today, the sign has not been removed.
So it would be good in the form of a motion to add those 2 items.
No, she's writing it,
I think that's,
rewrite it,
Okay, you want me to read that one?
please.
Okay, that the reasons for the previously mentioned motion are: 1, there is no documentation to prove that the previous administrator, Bo Bernhoft, gave approval for the small sign to be erected. 2, the plan commission has met on 5 occasions and on each of those occasions gave direction to the village administrator that the small sign should be removed, but as of today, that still has not occurred.
Okay. Those are good. Well, wait, can we do all at once,
Yeah,
All right, the third one would be, is that the sign exceeds a present sign dimensions or approved footage. That's
okay, so the sign that is currently erected exceeds the allowable amount of parking signage in the village. Is that right?
You're a good interpreter.
I think you said exceeds size.
Okay, the
Maximum
sign that
size.
is currently erected along the road exceeds the allowable size of parking signage in the village. Is that right or not?
square footage.
The allowable.
Are you talking about, you're just talking about the little hanging sign? So,
But it's a combination.
No, it's a combination.
oh, okay, you're gonna do that, okay.
You have to, it has to be,
How about if we say the parking sign that is currently erected along Mill Road for the Dorr Hotel, the parking sign. Currently along erected signage, how about that, because then that includes both of them. It is currently erected along Mill Road for the Dorr Hotel. Exceeds the allowable amount of parking signage that the village will allow. Or exceeds the amount of parking signage that is allowed in accord with the zoning code provisions.
Yes.
Okay,
it's not parking signage, it's just signage.
isn't it parking signage?
No,
Well, if you're gonna include the
Business
big
sign.
part,
Is that what it was?
says door.
Julie said it was parking
Sign
signage. I believe.
dimension.
Oh, okay, okay, I got it wrong.
Okay, so what now? Do you want this to say? The signage for the Dorr Hotel? Or parking signage?
Well,
the presented, the signage presented exceeds the village authorized square footage.
Oh, I like the one, thank you.
Right.
Okay, exceeds the allowable amount of parking. Square footage, parking signage, square footage.
of signage square footage.
We don't, we'll take the word park.
Parking over there, okay, that's something. Okay, signage, square footage. That is allowed in the village. Okay,
Okay, Janelle, if you can read those three.
okay. There's no documentation to prove that the previous village administrator, Will Bernhoff, gave approval for the small sign to be erected. 2, the plan commission has met on 5 occasions, and on each of those occasions, gave the village administrator direction that the small sign should be removed, but as of today, that has still not occurred. 3, the signage presented exceeds the allowable amount of square footage of signage that is allowed in the village.
I believe the plan commission has 4 times.
4, okay. Now you need somebody to make it and second it.
So I will make the motion and Janelle will read it.
Okay. A motion was made by Sadler that the reasons for the previously mentioned motion are, number 1, there is no documentation to prove that the previous village administrator, Will Bernhoff, gave approval for the small sign to be erected on village property. Number 2, the plan commission has met 4 times and gave the village administrator direction that the small sign should be removed, but as of today, that has not occurred. 3, the signage presented at this hearing exceeds the allowable amount of square footage of signage that is allowed in the village.
Is there a second? Okay, all in favor? We'll go around the table.
Aye.
Aye. Abstain.
Aye.
Okay. Motion is carried. Make a motion for adjournment. And
6:08.
6:08.
6:08. A second.
Second.
All in favor?
Aye.
Motion adjourned. Thank you all.